As Suhas mentioned, I'm going to talk about patent valuation, essentially in the area of standard essential patents, and see the interplay of the FRAND terms, which are kind of obligatory for the SCP holders, with the competition law, which is developing in this country. As all of you probably already know, that for valuation in IP in general, you have two broad methodologies. One set of methodologies basically are quantitative in nature, where you look at the income, you look at the cost, or you look at the market to determine the valuation of an IP. What is probably more relevant for patents is the qualitative analysis, where you look at the scope of the claims, you look at the geographical coverage and things like that to take a call on what kind of valuation the patent has. But then, as a patent practitioner, I often look at the valuation and the various litigations that we are seeing across the world, and that often makes me think that, hey, at times, IP valuation could be quite speculative. And when I look at, some of the interesting observations made by the court, I came across this observation by a court in the Federal Circuit, where the judge actually directed a retrial, stating that the study by the patentee, and in this case it was the SEP holder, the judge said the patentee's damages expert was predicted on speculation and unrealistic assertions, and supported by the trial court's conclusion that the expert's study was pure fantasy. And that makes me wonder that, do we require better tools? Do we require better software products? Do we require more parameters to be taken into consideration to arrive at a more realistic IP valuation, as Suhas talked about, whether we are overvaluing IP in some form or shape or not. And then I look back at something which economists said 150 years back and say, hey, patents are like lotteries, where you have a few prizes and a lot many blanks. And now when you link that to SEPs, you have some real big prizes. Just to make sure that we all are on the same page, we all know that in the area of telecom, for example, you have certain standard setting organizations. So what happens is that we all realize that there are certain technologies that several players in the industry require. For example, Wi-Fi, for example, specifications for the pen drive, for example, CDMA technologies. We all know these technologies are required to be made available to all the players in the market to bring about interoperability. So once certain standards are set by the standard setting organizations, the patents that cover those standards become standard essential patents, right? Now the deal is, just to make sure that the society is able to strike a balance, SEP holder is pretty much obligated to issue the license to the interested parties on FRAND terms, which is that the licensor or the SEP holder has to be fair, has to be reasonable, and has to be non-discriminatory when he issues a license to an interested party. Because he knows that the SEP holder is actually acting like a gatekeeper to the market. So the players in the market won't have access to that market unless they go through this gatekeeper who's a SEP holder. So therefore, it's obligatory on the part of SEP holder to be reasonable in its conduct to grant SEP the licenses to the interested parties. Now the question comes in that the fact is that SEPs, because they are important, generally enjoy a better valuation than the regular patents, right? Now the question again comes in that, are they overvalued? So let's understand how courts have looked into these issues for SEPs. And now I'm going to quickly run through 4 cases that we are having presently in India on SEPs. They all are at very preliminary stage, so I'm going to quickly run through these 4 cases. So you have the first one where you had Ericsson versus Micromax, where Ericsson is the SEP holder for about 7 or 8 patents which are under consideration in this litigation. Matter heard at Delhi High Court, ex parte injunction order passed, appeal was filed, the injunction was vacated, and certain royalty rates were fixed. So if you see in this column, you have certain royalty rates which were fixed by the court. Anyone and everyone who looked at these rates said, hey, these rates appear to be on the higher side. Point well taken that yes, of course, these are SEPs, they are important technologies, there has to be a reasonable royalty. But everybody looked at these rates and said, hey, these are on the higher side. Now the question comes in that the court directed both the parties to enter into a negotiation and try to have a license arrangement on frank terms. Both the parties made an attempt, failed to arrive at some kind of an arrangement under frank terms. Matter went back to the court. Now, court is adjudicating this matter. In the interim, the attention of the court was drawn to the fact that, hey, Ericsson is already having a license agreement on these very set of SEPs with several players in the West or other parts of the country, other parts of the world. The court asked for the agreement under confidence and revised the rates. So the point I'm trying to draw here is that first, it's unclear how court arrived at these rates, which appear to be on the higher side for SEPs. And then when Ericsson showcased the kind of rates it had, royalty rates it had, for the same set of patents in other geographies, the Delhi High Court revised the royalty rates. So what I'm trying to say here is that the courts are playing some role to bring in royalty rates, even though at the interim stage, which are a little more realistic than what a SEP holder believes his patent deserves to be. Similar instance we had in the recent case, which is again sitting with Delhi High Court, Ericsson versus Xiaomi. Here the court arrived at 100 rupees as an interim arrangement till the time the matter is adjudicated. And often people say, is that adequate, or is it still an overvaluation in some form or shape of the standard essential patents? Similar instances in the case of Waringo versus ZTE, two cases, one in the area of CDMA technology, another one in the area of GSM patents. Similar observations. The trend we are seeing, at least with the Delhi High Court, which handles majority of the patent litigation matters in India, is that unlike in the pharmaceutical space, where it is becoming harder to get ex parte injunction order, at least in these 4 or 5 cases that we have in the telecom space in India, ex parte injunction orders have been passed, and then in some form or shape they have been vacated or modified, and certain royalty rates are fixed. And in a lot of cases, people believe that the courts are trying, in India at least, in some form or shape, trying to bring in little more realistic flavor to the valuation of such SEPs. Though it's too early to comment, but that's the early trend we see. Now, this is what we have seen, how Indian courts are treating SEP matters. And I think the case law will develop over the period of time. But let's take a quick look at how the West has looked at these issues. So this is a US case that I have picked up. In this case, Motorola owned some SEPs, and the case was filed against Microsoft. Motorola sought 2.25% as a royalty rate. Ultimately, the court arrived at a royalty rate which was significantly lesser than Motorola was seeking. So there was a huge drop from $4 billion that Motorola was seeking to the order when ultimately the figure was just about 1.8 million USD. The question also comes in then how those valuations were done, which methodologies were employed, and is it now a reasonable compensation to Motorola? These are the questions which often make me wonder that the tools that we have, are they adequate to bring in more realistic flavor to the valuation? So the case that I showed you was from US, and this one is from Europe. And this is the case where Apple was found to be infringing certain SEPs owned by Motorola Mobility. So Apple went to the European Commission and said, hey, we as Apple did anything and everything that we could to get the license from Motorola Mobility under frank terms. So we are interesting, willing licensee in this case. We want to have a license, but Motorola Mobility did anything and everything it could not to let us have the license under the frank terms. The European Commission investigated the matter and did find that Motorola did abuse its dominant position and intentionally dragged the negotiations to ensure that Apple is not able to enter into that marketplace using the technology sitting in the SEPs owned by Motorola Mobility. And damages were awarded in this case. So what we are seeing is that there's an element of uniformity where, of course, FRAND terms are relevant, but the general impression I get is that the SEP holder has slightly more obligation to reach out to licensee or interested licensee and say, hey, we'll be happy to give you the license so that you can also be a player in the market, and we will ensure that we are giving it to you under FRAND terms. But then you can always ask a question, what is reasonable? How do you quantify that the behavior of the SEP holder is reasonable or unreasonable? So these are subjective issues which cannot be really handled in a mechanical manner. But clearly, we felt that courts will look at the issue more appropriately in coming days. Now, we have seen that FRAND terms have been handled by the courts. European Commission has also looked into the issue. Let's come back to India and see, in view of the SEP cases that we have had, do we have any antitrust or competition law proceedings in India? Because when you have this SEP holder who has a dominant position in any case, how do you bring in those checks and balances to ensure that the SEP holder operates more reasonably? And that's where the competition law comes into picture. In India, we have the Competition Act of year 2002, but actually came into functionality only in year 2009-10, when the infrastructure was put in place and the Director General was appointed for this matter, for the Competition Commission. And since then, you would have seen that the Competition Commission has been very, very active in several matters, right? So you might have heard that one of the very big developers, the real estate developer in northern part of the country, was heavily penalized for abusing his dominant position, right? And there are several other cases that CCI in India has handled very effectively, and some significant amount of damages have been awarded. The most recent one is in the area of automobile, where several OEMs have been penalized. Now, what is interest of us is whether the Competition Commission of India has looked into SEP issues or not. And interestingly, yes, the Competition Commission of India has looked into SEP-related issues. And the two cases that the Competition Commission has handled so far, one is Micromax versus Ericsson, another one is the Intex versus Ericsson. In both the cases, in first case, Micromax approached Competition Commission and said, hey, Ericsson owns certain SEPs, and we have made effort to get the license from them. But the problem is that the royalty rates which are suggested by Ericsson are a bit too high. Similar argument was put forth by Intex in front of the Competition Commission of India. As you might be aware that the Competition Commission of India has an investigative arm, they can investigate the matter. So in both these cases, the Competition Commission investigated the matter and arrived at the conclusion that yes, Ericsson has indeed abused its dominant position and has sought licenses at rates which are seen to be a lot more on the higher side than what courts or the commission felt were appropriate. The matter is still sitting with the Delhi High Court, so Delhi High Court in the interim has told Competition Commission not to pass the final order till the time the matter is fully heard at Delhi High Court. So this is a broad situation we have, but just to summarize what I said, so you have patents which become a lot more powerful when they become SEPs, and then comes the issue whether in terms of valuation, are they overvalued, and what mechanism, if they are indeed overvalued, what mechanism can be employed to bring in more a realistic element to the valuation, and how do you ensure that both the licensor and the licensee conduct themselves properly under FRAND terms, and how do you bring in checks and balances by way of a competition commission to ensure that there is no abuse of dominant position. With this, I conclude my presentation, and I'll be happy to take questions that you may have, maybe at the end. All right. Thank you so much.